Ever felt like your job needs a little tweak because of a disability or medical condition? Let's talk about that. Welcome to Gateway to the Law, your go-to channel for demystifying California's legal maze. I'm your host and partner at Gateway Pacific Law Group, Roger Haig. And whether you're just curious or seriously considering legal action, you've come to the right place. This video is not legal advice. It's meant to be used when you think you need some basic information about a legal concept so you can decide whether to call a lawyer. We break down complex laws into easy-to-understand, bite-sized chunks, helping you decide if it's time to reach out to an attorney. So sit back, relax, and let's talk about the interactive process. Sometimes, employees need a little help at work to do their job because of a disability or medical condition. It could be as simple as a temporary flexible schedule for doctor's appointments. Maybe an employee needs periodic breaks to stand or sit in order to relieve or prevent pain. Or an employee might need a medical leave of absence to recover from their injury or a medical procedure. Well, guess what? California law says your boss has to work with you to accommodate your disability. This process is called the interactive process. Imagine your situation is like a game of hopscotch. You're stuck on a square because your leg hurts. You have a disability or medical condition that makes things tricky, like that bum leg. The interactive process is like someone offering a helping hand to hop to the next square where you can do your job with ease. The first important thing you need to know is that you don't need to say anything fancy or initiate special paperwork to get the process started. Just tell your boss about your situation. Explain how your disability or medical condition is making things tough at work. Don't get too technical, just be clear about what's getting in the way. Once your boss knows that you need an accommodation, they can't just ignore or instantly deny your request. They have to engage with you in good faith to try and find helpful accommodations. This means your boss and maybe human resources should meet with you to hear you out and ask questions to understand your needs. You and the company may review documents you have from your doctor, like a doctor's note. If you don't have one, they may ask you to provide them one. Then, either at the meeting or some reasonable time afterwards, you and your company should explore what accommodations they can provide you. Basically, you're brainstorming together. Maybe you need your job modified, or you need a leave of absence or special equipment. Also, this is not a one-and-done situation. You have to let the company know if the accommodation doesn't work. The company has to continue to look for an accommodation that will help you do your job or permit you to continue working. It is called the interactive process for a reason. You both have to interact with each other to find the accommodation that works for you and the company. Before we move on, if you like what you see and you want to read more information on laws that affect you as an employee or consumer, you can also go to our YouTube channel description, which has the links to our social media channels and our website. Our website has blogs about various employment law-related topics and even helpful documents like checklists to download. Also, consider hitting the like button. Hitting the like, subscribe, and notification buttons help us grow the channel so we can get helpful information to other consumers and employees. And if you wonder why people are always asking you to hit the like and subscribe buttons, it's because doing either of these actions helps bump up the video in the search results, so more people are likely to watch it. Now, back to the video. Here are two no-nos that we commonly see happen in the interactive process. First, employees saying they are afraid to tell their company that they need an accommodation or waiting too long to say they need an accommodation. The law doesn't protect you unless your company knows you need an accommodation. The second issue we commonly see is employers that immediately refuse or ignore accommodation requests. Companies that don't even try to find ways to help an employee who needs an accommodation are usually violating California law. Oh no, she missed the trash can and violated the law. Remember, the interactive process is not supposed to be combative. It is a team effort where employers and employees are respectful of each other to help the employee get back to work. If you believe that your employer is not working with you in good faith to accommodate you, contact an experienced employment law firm like Gateway Pacific Law Group, who can go over the facts and discuss your options. So, California workers, don't be afraid to ask for help if you need it. With the interactive process, all employees can reach their full potential. Law is the compass of society, guiding us to justice. Until we meet again, stay true to your course.